Welcome to Epstein, Becker, Green's Employment Law This Week podcast. I'm George Whipple. The Equal Employment Opportunity Commission is poised for a dramatic transition. But when and exactly how much change? That's what we're looking into this week. In July, the current administration released a unified agenda of regulatory and deregulatory actions for 2026. This sweeping agenda involves dozens of agencies and hundreds of regulatory revisions designed to advance the administration's objectives. The EEOC has been clear about its alignment with the administration's agenda, putting it at the forefront of this transition. A national enforcement plan, published in June, lays out the Commission's priorities, which include remedying DEI-related race and sex discrimination, and protecting American workers from anti-American national origin discrimination. The EEOC is not shying away from changing rules and guidance that employers have worked under for decades. The Commission has already rescinded its 1979 Affirmative Action Guidelines and recently announced plans to eliminate data collection that has been required for 60 years. Still, much of this action is in the planning or proposed stage, which generates uncertainty for employers. We asked Epstein, Becker, Green's Ann Knuckles-Mahoney to look at a few key areas of the EEOC's regulatory agenda and help employers figure out what we know and what we don't.
The agenda does not on its own provide any new or removed regulations, but instead signals the EEOC's intent for future action. Further, it doesn't change any existing laws. Any employer action relating to what's set forth in this regulatory agenda should depend on further EEOC action and consideration of the laws that remain intact.
The EEOC's agenda includes 10 projects that are in various stages of development. One item at the final rule stage is a rescission of the 1980 guidelines on discrimination because of national origin. Employers should expect EEOC action on this soon. What other changes will we see in the near future, Anne?
On July 23rd, the EEOC formally issued its proposed rule to rescind and remove the requirements for filing of the EEO-1 and its companion EEO reports, as well as the record-keeping and record preservation requirements related to those reports. A public hearing on this proposed rule is scheduled on August 11th, and employers can submit comments until August 24th. While employers await final EEOC action and monitor for any subsequent litigation on the reporting requirement, they should continue their current data collection procedures.
If and when this rule becomes final, employers will still need to comply with any state laws that require collection of demographic information. Tracking this data will also be useful in defending against lawsuits. Another item on the agenda is a proposal to revise the Pregnant Workers Fairness Act. There has been a lot of debate and litigation around that one.
The abstract summarizing these proposed changes provides little detail other than revising language in the regulations regarding the interpretation of the words pregnancy, childbirth, or related medical conditions. However, EEOC Chair Andrea Lucas has been vocal about her opposition to certain parts of the PWFA regulations, finding the rules to be overly broad. Likely changes include narrowing of the definition of related medical conditions and removal of accommodations for abortions, menstruation, menopause, and contraception.
We'll keep watching this one, but it's likely that nothing will change for the PWFA this year. The agency is aiming to issue its proposed revisions in November, with a public comment period ending sometime in January. As changes at the EEOC and other employment agencies move from statements to proposals to final rules and guidance, we'll keep you updated with all the information that employers need to know. Thanks for listening. We'll see you next time.
This podcast is presented by Epstein, Becker, and Green, PC. All rights are reserved. This audio recording includes information about legal issues and legal developments. Such materials are for informational purposes only and may not reflect the most current legal developments. These informational materials are not intended and should not be taken as legal advice on any particular set of facts or circumstances, and these materials are not a substitute for the advice of competent counsel. The content reflects the personal views and opinions of the participants. No attorney-client relationship has been created by this audio recording. This audio recording may be considered attorney advertising in some jurisdictions under the applicable law and ethical rules. The determination of the need for legal services and the choice of a lawyer are extremely important decisions and should not be based solely upon advertisements or self-proclaimed expertise. No representation is made that the quality of legal services to be performed is greater than the quality of legal services performed by other lawyers.